in part of the training, in fact.
Hello again, we're back. We're watching the Todd Kendhammer testimony. We just saw his testimony when he took the stand. Obviously not usual for a defendant to actually take the stand, but he did in this case, and he kind of had to because he really needed to explain what happened on that day that his wife was killed. And there were so many interesting parts of this trial. Todd Kendhammer was convicted yesterday by a jury. And interestingly enough, today we have Alan Tuerkheimer. He is a jury consultant, and he's going to take us through some of the issues that came up in this case and also just how important a jury is to a case generally. Alan, thank you so much for joining us today.
Nice to be here.
Well, we've got a lot to talk about here. So first, let's talk about this Kendhammer case. This was kind of a crazy case. When you're talking about somebody with such a elaborate cover-up, at least according to the prosecution. I mean, now he was convicted by a jury. That's a hard thing to sell, that somebody had such an elaborate plan to cover up a murder. And oftentimes that doesn't sit well with the jury. What do you think happened here? Who did they have on their jury that they got a conviction under those circumstances?
They listened to each of the case narratives. I mean, you had the prosecution on one side, you had the defense, and a big part of this was, I think the jury in their minds, they listened to the actual defendant get up and testify and decided for themselves, could he have done this? Was he capable of doing this? Did he do it? And as you mentioned, it doesn't happen very often when a defendant takes a stand in a case like this and did it, and the jurors didn't believe him. He didn't sell it to the jury. So they deliberated. I think it was 9 hours or so. I'm sure they went over all the evidence, the testimony, and no doubt that they talked about him when he was on the stand, and they felt that the prosecution proved its case beyond a reasonable doubt.
Right, absolutely. And I agree to a certain extent that the defense had a few issues here, and a lot of it came down to that testimony. Now, in your experience as a jury consultant, you don't see the defendant in a criminal case on the stand. That can sometimes not sit well with the jury, although it's not supposed to matter. And then the jury will be instructed not to take that into consideration. But how do you weed out the people on a jury that may have a bad taste in their mouth if they don't hear from the defendant personally?
Right, because in mock juries and in actual trials, it happens, it's invariable that some of the jurors are going to want to hear from the defendant. They say that they have to hear from the defendant, everything would influence the outcome if they heard from the defendant. So it's really hard to do that. You have to weed that and tease that out in voir dire. Just have to make sure that you get jurors who are okay with the notion that you might not hear from the defendant, don't make any negative inferences to the defendant, and you really have to listen carefully during the jury selection process to what jurors are saying, how they're saying it, to make sure that when you seat a jury, if you're from the defense perspective, they're not going to use it against the defendant if they don't testify.
Right, that's always a critical piece. But as a jury consultant, in addition to helping attorneys to find juries that will help their case, you also have another role, and that's communicating and articulating the person that retained you side of the case. So if you're working with the defense or the prosecution as a communications expert, social science expert, isn't that really part of the jury consultant's job to make sure that the message is being weaved through the whole trial, laying the foundation for the case?
Absolutely. You're doing a good job of overviewing my profession and my title. Absolutely. It was one of my duties. Once the jury's seated, then you have an audience. You have to communicate your message to the audience. You have to know your audience. And the most effective way to convince the audience of your point of view is to make a message that resonates. That's what language do you use, what arguments resonate. You have to make sure that you're not boring the jury. You want to keep the jury focused. You want to keep the jury interested in what you're talking about. And you want to really empower the jury to connect the dots. A lot of times I tell clients that you're an attorney and they don't know you. They don't know you. Maybe you talk to them a little bit in voir dire, but you don't have instant credibility with the jury. So if you start telling them what they should believe, what they have to believe, what they have to see, they're not going to like that. They're going to check out, reinforce certain negative stereotypes that jurors have attorneys. So you have to lay out your case early on, in opening, and empower the jury to connect the dots in a way that's most favorable to you and your client. And that's a big part of it. You have to find your message, you have to communicate your message effectively, and make sure that the way you're communicating it is going to ultimately be embraced by the jury.
Absolutely, and that's a really critical part of your position. Now, you watched the Kendhammer case. What did you think about the defense and the prosecution and the way that they laid their case out and their theory of the case and weaving those themes throughout the course of the trial? Who do you think did a better job?
I think they both did a pretty good job. I think ultimately it just came down to the jurors decided they didn't believe the defendant, but the state really stuck to their message and they hammered it through and through. They talked about how he changed his story. I think 3 versions of it. And what they said was it was very concise, simple, plain spoken language that he did this and then he tried to cover it up. Now, certainly the cover up was pretty extensive and he went to great lengths according to the prosecution to do so. But I think the jury just got this message hammered over and over and over that he did this, whatever the motive was, if it was something on the morning when they were driving, he was taking her away from work to go wherever that he was going to go, which changed a couple of times, that he had the motive to do it and he did it, and then he decided to cover up. Plenty of time to do it, and that's what we're sticking with. And they said that over and over and over, that he was the one that did it, and now he's trying to make this huge cover up.
Right, and there was a lot of focus during the trial about his credibility, and credibility is key in a situation like this because you have to believe his version of the facts in order to acquit him, so that's certainly a big piece there. Now, another interesting part of this trial, and I really think watching this all the way through, covering this gavel to gavel, that this case was really won on expert testimony. I definitely think Kendhammer's testimony was certainly very influential to the jury, but the experts here were key because experts were testifying about whether or not injuries that the victim sustained could have been done by this pipe falling off a truck. So as a jury consultant, Alan, I know that when I'm trying a case, experts is where you lose your juries so often. How do you, in a heavy expert case, how do you weed out the jurors and make sure that you keep those jurors listening to some of that critical testimony that really is important to the ultimate result of the case?
Sure. One of the things is you just have to try to make sure you don't have a juror who's going to become the status expert in the jury box. You want a jury expert, a jury knowledgeable, there's a different type of expert for a certain case. If it's a medical malpractice case, you have somebody in the health field who's going to become a resident expert. If it's a car case, somebody who's a quote-unquote shade tree mechanic, they're going to talk about all the inner workings of a car. Criminal case, you might have somebody who is married to a paralegal at a law firm or somebody. So you just want to make sure that you have jurors that are going to keep an open mind, that are going to actually listen to the expert and not substitute their own judgments, their own inferences, their own selective memory instead of the expert. So you really want to know and voir dire when you're picking a jury what the experiences are. You have to back up the questioning and just understand our expert is going to be open and give our expert a fair shake at it, and who is going to be the opposite and come in and say, I made up my mind, I'm not going to listen to the expert. And then if you really believe you have a better expert and you want to make sure that your expert speaks to the jury best way that sells your case, and moves on from there. Interestingly, sometimes when experts concede something, this happens over and over in talking to jurors, experts don't have to, you don't want an expert, you want your expert to be making arguments and pointing things out on your behalf, but you don't want them to be an advocate. So it's okay once in a while if an expert makes a small concession, says something that might be favorable to the other side. That enhances their credibility. So the bottom line is you want an expert who's genuine. You want somebody who's going to come off as authentic, who's not there for an agenda. And the flip side of that is you want to have a jury that's going to be open to listening to that expert, give his or her perspective of the case.
Yeah, certainly that is very important because in a case like this, and I really do think that that's one of the reasons that we saw a conviction, you saw the defense expert get on the stand and give this almost hybrid response. Well, the injuries could have been sustained by the pipe, but yeah, it also could have been something else. So that really was something that was pretty damaging to the defense case, and obviously that expert testimony is very, very critical. Now, Alan, I want to talk to you a little bit about just as a jury consultant generally, how you work up a case. I will never forget what a federal judge said to me one time on the eve of trial. He said, you will have an honest roulette wheel in my courtroom. And that's really how many attorneys and clients view these cases, that look, there's no guarantees. It could go one way or the other. You could have the strongest legal argument and ultimately lose the trial. And one of the ways to help control that risk is to hire somebody like you to help us through communicating our case to the jury, and also to pick jurors who are not going to come in with bias and are going to come in and give us a fair playing field. So how do you do this with these different types of cases? We saw, Bill Cosby, for instance. Now that is like national news. There's not one person in the world who's never heard of the Bill Cosby case, who doesn't know what's going on. And you don't even want somebody who doesn't know what's going on in the world on your jury. So you're kind of stuck between a rock and a hard place. How do you deal with a high-profile case like that?
Right. Well, what you were saying at first, jury selection obviously matters, and it's not just me that says that, but think about it this way. If you have 48 people that show up for jury in the panel, and you have to see 12 jurors, the first 12 are going to see the case differently than the second 12. You're going to get a different result no matter if it's the first 12, the second 12, the third 12, or fourth 12. So you have to go through it, and you want to make sure that you get jurors who are going to be not going to be receptive to the other side's case. One of the reasons, as you mentioned, that it's important to have somebody know social science is that in law school, lawyers are not taught of jury selection. Lawyers usually, when I ask the lawyers what they don't like, what their least favorite part about trials are, it's picking a jury, because lawyers are used to cross-examining a witness. They're used to hammering someone, used to pushing a witness to get them to agree with their point of view. They're used to being adversarial. Jury selection is the exact opposite. You want to elicit a conversation. You want to do 75% listening and 25% talking. So you want to take a step back. It's very different. A lot of lawyers are not comfortable with it, and so that's why they often bring consultants in, just because it's not their favorite part of trial. And in jury selection, you want jurors to talk, and jurors think that they have to argue. That's not what they're supposed to do. So in terms of the type of case it is, a high-profile case is certainly different. If you're picking a case that has local attention, like the Larry Whaley case in Mason City, Iowa, that's very different than Bill Cosby, because you are going to have people in high-profile cases that, for some reason or another, they feel like they have some kind of connection to the defendant, or conversely, they might have some animus towards the defendant. And depending on which side you're working for, you have to identify that juror. There might be a stealth juror that's going to skate along and maybe try to minimize certain answers or exaggerate certain answers to get on the jury because they have an agenda. So you have that extra layer of concern when you're helping pick a jury in a high-profile case.
Certainly, and it's very difficult because, again, you never want somebody who's living under a rock. You don't want people who don't know what's going on in the world. So you're you're stuck in a situation there where it's very difficult to tell if somebody has read something that's made them biased. And sometimes, and you're the expert in this, not me, but I'm talking about from my own experience picking juries. Sometimes you can't even, with any question you ask, the juror might not even know that they're swinging one way, that they're a little biased. They're not doing it purposefully. It's just that everyone's interpreting the information based on their own experiences. So how do you translate that into picking a jury?
That's hard. You hit the nail on the head. A lot of times people, most of the time, they're not aware of subtle biases that exist from within. And when jurors are in open court and they're asked either by attorneys or by judges very pointed questions about being fair, there's certainly social pressure to say that they can be fair. Nobody's going to admit to being a racist in open court. Well, somebody might, but most people aren't.
Just Larry David on Curb Your Enthusiasm.
Right.
In an episode, but probably very rarely does that happen. Yes.
Right. So you get that. You get sometimes you get little sideshows where people trying to get off, but in general, nobody's going to. First of all, they're often not aware of it. But even if they have a subtle bias that they're aware of, it's really hard to communicate that. So that's what consultants have to do. That's what lawyers have to do. I'm sure you've done a good job of this. I can tell you'd be a good trial lawyer. You're good in front of people, and you'd be pretty persuasive. I think you probably could tell who's going to be aligned with your case and who's not going to be. But you really have to let the jurors do the talking and then decide who's going to use it against your client and who isn't, who's going to be biased and who isn't. If somebody subtly moves when you ask a question about it, you really make a movement perhaps when you ask about, can you be fair to my client? You might feel like it feels like they're going to say something. Maybe they have a bias, but they're not quite comfortable doing it. Well, that's something you can pick up on and voir dire when you get at the jurors. questions are being asked, they often indicate insights into their mindset based on nonverbal behavior. So that's the trick, though. It's really hard to get jurors to flat out say they're biased, other than certain exceptions. But you really have to listen to the language they use. You have to understand where they're coming from, what their background is, and then decide, if this person's in deliberations, what do I see? You want to think about how they're going to be biased if they are, and you almost want a sneak preview of what deliberations are going to look like. And that's how I sometimes conceive of voir dire. I think, all right, can I picture these three over here or a couple here? What's deliberations look like? And certainly that bias question is the key thing you're looking at.
Right, Alan, and you made such a great point, and I think that's great advice for all trial lawyers. Listen to the jurors and pay attention. Lawyers, and I do it myself, you get bogged down in where you're going to go next, to the theory of the case, and a lot of that, and you forget to actually pay attention to the information that's coming to you.
Right.
Another point I definitely want to get into is, what do you think about alternate jurors? I know in the Kendhammer case, we had a little bit of a weird situation. The judge did something a little odd. Can you explain that to our viewers?
Yeah, from what I understand, so there were alternate jurors that were seated, and this happens in all the trials where you seat jurors and then somebody gets drastically sick and can't serve or gravely ill, or something comes up, you have to fill somebody in. So they have extra jurors because you do lose jurors from time to time. Well, they were going to determine the order of alternate jurors, and to give them numbers to see who would feed into the jury, the judge said to the defendant, I believe, pick a number, what is it, between one and however many alternates there were, and he had to pick a number, and so the defendant, which is completely random, and it's completely fair, it's a very unusual technique to do it, so the defendant gave his numbers, and then I think that determined the order of the alternates that would have been chosen had they filled in for a deliberating juror. Yeah,
that is interesting. I've never seen that done before, but I suppose you're right. There really wasn't any reason to think that it was fixed or anything. So it was completely random. So there's probably nothing that the defense could use as perhaps a means of appealing the case with that situation, but it certainly was interesting. Alternate jurors are always a tricky situation, and it depends on where you practice, because the law is different in every jurisdiction, how alternates are treated. Now, in many courts, alternates don't know that they're alternates on a jury until they're actually going into deliberation. So they're still involved in the trial. In other jurisdictions, it's different. You might know that you're an alternate. Do you think that has an impact on those jurors taking in the information and really having a stake in the outcome of the case?
Yes, and just what you said there, they'll process the information differently, because jurors want to, especially if you think about it, they're not being paid much. They're asked to make big sacrifices. Once they are seated on a jury, they want to have their voice heard. They want to have a say. So alternates are aware of the importance of being alternates, but in the back of their minds, they think it's never really going to amount to anything. I'm probably not going to fill in. I don't think they're going to pay as close attention to the case. And then once set loose, more often than not, I find that alternates want to stick around and, if not talk to the jurors afterward, at least find out what the result was, because they're vested in the case. They spend a lot of time and psychological energy looking at the evidence, hearing from the witnesses, so they want to somehow be a part of it. And it's consistent with this notion that jurors want to make a difference. In the tobacco trials, a long time ago, 20 years ago, the case in Minnesota was, it was like 7 or 8 months. Some jurors lost their homes, jobs, everything, but they served, and then before they were deliberating, the case settled. And if you think about it, that's such a disruption in their lives. And to what? There would have been more solace had they actually made the decision and come together and spoken as one voice of a jury. So, yeah, the issue of alternates is very important, and I think it's good when they don't know that they're alternates. Side of that, of course, could be that, well, then they're disappointed when they don't get to actually deliberate, but they know that there's some alternates out there. But I think it's better if they don't know that they're alternates when it comes to.
Yeah, I tend to agree, because it really is harder to be invested if you ultimately don't think you're going to be one of the voices that will be heard at the end of the day. So I do agree with you. I think it's better when the alternates don't know, and then the chips fall however they fall at the end. But those people have been actively involved. I want to turn back to you, and you referenced it, the Larry Whaley case, which we'll be covering next week. I mean, this is this is a tough case because you're talking about a small town, a lot of publicity in a small town. You're also talking about a really tragic death. Samantha Teeter, 19 years old, fatally shot. Larry Whaley pleading not guilty. That's why we see ourselves going to a trial here. How do you get a fair jury in the small town arena? That is a really tricky situation for a defendant.
Correct. They might have to use a lot of cause challenges to get rid of people, and they just have to, during the jury selection process, identify people who say, yes, you know what, I know about this, and I would have a tough time being fair to the defense. So if you go through that enough, then if you think about it, if you get rid of all those people, then you will have a pool that at least, even though they've been exposed to the information, indicates that they can be fair, that they can forget what they've heard, they haven't formed an opinion, because kind of to your point earlier, people who have not lived under a rock are going to know about this case. It's been in the news. It's a local case that's a pretty small, very white county, which is, I think, it was like 99% white, I think, and the defendant's black. So you have these issues, and I know he was making some goodwill letters to the judge, and he's trying to get it out of the county, but he chose to live in a county like that. Those are his peers, and so you have all these issues swirling around. Some jurors are just going to flat out say they can't be fair, and the other ones who, even though they've heard of the case, that's okay if they haven't formed an opinion. So I think it's going to be very critical that the judge, the attorneys, listen very carefully. Again, it goes back to listening during voir dire, because that's the key. It's not talking from the attorney's perspective. Listening to what the jurors have to say about what they know and what they have done with that information.
Yeah, certainly. And it will be interesting to see how that plays out. And we'll definitely want your insights during that Larry Whaley case when it commences next week. Can give us a little bit of your thoughts on how they did and how the themes of the case are being articulated by the prosecution and the defense. What would you, Alan, let's end with this, because you've given us so much insight about both the Kendhammer case, about the Whaley case, and just as a jury consultant generally. What would be your one critical piece of advice to us trial lawyers out there when we're picking juries?
I would say that you shouldn't underestimate the juries that are out there. I think a lot of times attorneys, they're so immersed in a case, they've been living it, they've been breathing it, they tend to forget that, yes, jurors are lay people. They tend to forget that jurors don't know anything about the case. But that sometimes leads to a tendency to maybe talk down to jurors a little bit, or not give them the credit that they deserve. So I think that one of the things I would say is don't speak down to them and be yourself. Don't try to engage in theatrics. Jurors are really good at detecting who's making something up and who's genuine. So I would say be yourself. And yes, while you have to speak in plain language to the jury, empower them to make a decision in your favor without being condescending or spoken down to. That's what I hear a lot when I talk to jurors after trials, that the attorneys were very showy, wasted time, and they were putting on an act which was offensive to them because it was condescending.
Right. And that's also a great point, Alan, because sometimes attorneys don't realize that. So there's two things that you said that really struck me. First is the fact that you can talk to these jurors after the trial and really find out why they made the decision that they made along the way. That is very critical to the case and to a learning experience for the attorney.
Absolutely. That's one of the most informative ways to learn about your case, whether you win or lose, because kind of consistent with this notion that you're so immersed in the case, you might have a little tunnel vision. You think, oh, we have this great witness and this argument, and then you talk to the jury afterwards and hated your witness and they hated your argument. Whatever it is, it could be the reverse order of that. They're the ones that are making the decision, and when you talk to them, you get a sense of what worked, what didn't work, what they liked, what they didn't like. Did they like your pace? Were you wasting time? Were you deferential? Were you condescending? All sorts of information that can help you retool for your next trial or trials.
Right. And Alan, that another point, and I think this happens all the time. It is true. When you're a trial lawyer, you are living and breathing that case. Oftentimes, I mean, your other cases are going to the wayside because you're just so invested in the trial and you've worked up the case the whole way through. So by the time you get to trial, I mean, you know those facts inside and out. I find that oftentimes lawyers forget to communicate all of that information about their case to the jury. Is that something you help attorneys with to make sure their message gets across?
Yeah, so I'll try to see things through the eyes of a jury when I hear about the case, and it's amazing how there's sometimes just this real disconnect, because the attorneys on a much higher level, they have complete command of the facts, but there's certain gaps missing. And when I hear it through the eyes of a jury, there's certain basic things that they're leaving out of the story. Something so basic, not that they're hiding it or purposely trying to keep it out, but to them it's just so basic and so elementary that, and maybe just marginalized for whatever reason, they overlook it. But yes, they need to see things at a more full level, elementary level, because jurors come in, they know nothing about your case.
Absolutely. And Alan, we really appreciate you giving us these insights. You're an excellent resource for these issues. And I want to have you back and talk about the Larry Whaley case as we get through jury selection. I have a feeling that one might take a couple of days because they're going to have a hard time finding an unbiased jury. Alan Tuerkheimer, jury consultant, thank you so much again for joining us today.
Pleasure. Nice talking to you.
Thank you. So now we're going to turn back. We're going to review more testimony from the Todd Kendhammer case. We're going to go right into the courtroom, and then we're going to have some insights from somebody who watched this trial unfold.